Yes.
I think it's 4 in Grootfontein and 14 in Otjwarongo.
So in total, you are doing 80 cases.
Yes.
But they are not all those 80 cases are partly heard.
No, only those, it's 18 that are partly heard, but of those, 7 are for judgment.
7 are for judgment.
Yes.
Why is 7 for judgment? And is there any particular reason why you accumulated 7 cases for judgment?
No, I do not. I can understand where your question does come from, but no, I do not sit on judgments. It's just mere coincidence. It's
Very well.
that there are now so many.
Very well. Now, should you be appointed, how quicker or soon are you able to take up the appointment, given the number of the cases that you are presiding over at the moment?
June?
2.
June.
So you are confident that you'll be able to finalize all those 14 cases
I
within
have
that
looked at my
particular
roll,
time?
at my diary, and I have not placed, as far as I can recall, I did not place any cases that are partly heard beyond May.
Very well. Very well. Now, I would like to give an opportunity to the commissioners to ask you questions and to have an interaction with you. If I may start with the Deputy Chief Justice, please.
Before I ask the orders of substance I want to deal with, I just want to latch on to the discussion the CJ started with you. In the regional court, what is the highest sentence you have imposed?
20 years.
20 years. And what sort of matter was that?
It was a very serious rape. The complainant sustained multiple knife wounds. She was kept for 2 days, and she was also raped multiple times.
All these things, of course, get appealed. Was it appealed?
Yes,
And what happened? on
it
appeal?
was confirmed.
It was confirmed. Thank you. Can you explain to us the principles that govern recusal applications?
I think the first thing to say there is the old adage that justice must not only be done, but it must be seen to be done. In other words, as soon as there is a perception of bias from the party requesting the recusal, whether that perception may be reasonable or not, the magistrate or the presiding officer, whatever the case may be, should consider the reasonableness or not, or whether such a perception of bias might exist in the mind of the party bringing the application. And if it does, then, in my opinion, what I have always followed is better to err on the side of caution if there is an application for recusal. So I would, if there is a perception of bias, I would recuse myself.
Now, recently in Botswana, 3 judges of the High Court felt that the Court of Appeal there, that is the highest court in Botswana, breached the Constitution and set aside the judgment of the Court of Appeal. They said the judges of the Court of Appeal violated the Constitution. You want to say something about that? And locate it in the principles of the precedent?
State decisis.
Started decisis?
Who set it aside?
The High Court. For example, the High Court judges in Namibia, 3 judges sit here and say
The Supreme Court
got it wrong. We are setting it
violate.
aside.
Yes, that's one for the books.
Sorry?
So that's one for the books.
I see.
Yes, of course, the Supreme Court, if I transpose it to Namibia, is created by our Constitution's Article 78. It has inherent jurisdiction. It has been said that the High Court in Namibia has original jurisdiction. It is both a court of first instance as well as a court of appeal. But according to the Constitution, the Supreme Court is the highest court in the country, and in my opinion, it would not be correct for the High Court to set aside a decision of the Supreme Court based on unconstitutionality.
How can a decision of the Supreme Court be set aside under our Constitution?
According to my knowledge, it's been done once in the Lekunwe case. It is in terms of Article 81 of the Constitution, which reads that the Supreme Court can set aside its own decision, or a decision of the Supreme Court can also be set aside by an act of Parliament.
So an act of Parliament can set aside a decision of the Supreme Court?
According to the Constitution.
In what circumstances?
One doesn't come to mind. I am not, to my knowledge, aware that it has been done.
So Parliament can simply just pass a law and say we are setting aside the decision of the Supreme Court?
According to Article 25 of the Constitution, it is the duty of our courts to uphold, of all the courts to uphold the Constitution. It is, however, not only the duty of the judiciary. Article 25 makes provision that it is also the duty of both the executive and the legislature. So the legislature, in terms of Article 25, would also be bound by the principles as set out in the Constitution.
You are familiar with Article 81 that says that such an act of Parliament must be lawfully enacted.
Of course.
Yes. But just to add to the question posed by the Deputy Chief Justice regarding a case in a neighboring country, just to say that the highest court in that country also set aside ultimately the decision of the High Court. So that decision is no longer on it's not part of their jurisprudence. Yeah. Now, I would like to invite the Honorable Attorney General also to pose questions.
Thank you, Chair.
Good morning, sir.
Let's see, in terms of Article 31 of our Constitution, the state president enjoys certain immunities from civil and criminal proceedings. Under which circumstances does the president enjoy those immunities?
It is not something that I gave much attention to when I prepared, I must admit. I would assume in the lawful execution of his official duties.
Would that be then while he's still, or she's still in office, or in office? Or
While I cannot imagine that such immunity would extend beyond the term of office.
Now, there is certain provisions within our constitutions that provides extraordinary powers to the state president during the state of emergency. For example, Article 26 provides that during the state of emergency, the state president shall be entitled by regulations to make or by proclamation to make regulations that, in his opinion, justifiable for the protection of state security, maintenance of public order, etc., etc. In your own understanding, would the state president be entitled to also suspend any law, be it statute, formal law, or suspend the rights and freedoms that are protected in terms of our constitution?
Yes. If I can take an example, the right to freedom was curtailed, which is contained in Article 7 of the Constitution. The freedom of movement, if under the pandemic that we just experienced, that right was indeed curtailed through the proclamations that instituted a curfew, limiting the population's right of movement. But of course it was in the circumstances as was contemplated in your question. I've also seen that although nobody can be forced to work, forced labor, if it is in the interest of state security for people to perform labor in the interest of the country, then even that will be lawful.
The right of the accused to be brought to court within 48 hours? Can the president suspend?
It is always a balancing act, as is much with the work that we do. It is the right and the right of the accused to be brought before court within 48 hours of his arrest. That is his individual right, but that of course must always be balanced against the interest of the community as a whole.
Would you then say that those powers that are given to the president, are they subject to some limitations, or they are basically just open?
Nothing, no power under our Constitution is absolute. It is the exact purpose of the Constitution, excuse me, to rein in the abuse of power, especially by the legislature or the executive. So all decisions, Article 18 of the Constitution deals with administrative justice, which also squarely brings that within the principles of legality and the rule of law, that everything that is done in our country must be looked at as was set through the prism of the Constitution. In other words, if any party approaches a competent court in terms of Article 25, our courts will be able to rein in any such unbridled exercise of power.
Commissioner Shkongo, would you like to come in?
Good morning, sir.
We've had several cases dealing with circumstantial evidence. Recently, the Supreme Court and in the High Court, quite high-profile ones, also in your forum, at the level of Magistrate Court and also High Court.
Yes.
And there's been judicial pronouncements on those. Could you just share with us, pick any one of those, and share your insight into how the court dealt with the issue of circumstantial evidence and whether you agreed with the approach taken?
Yes. Excuse me, sorry, I've got bronchitis. Yes, The test, of course, is State versus Blom. Whether the inference the court wishes to draw is in alignment with the proven facts, and if that is the only reasonable inference that can be drawn from the proven facts. So that is always the benchmark that you move from. Sorry.
You can take some water. Is that your water?
No, that's
Yes.
fine. Thank you. I think what is very important to understand is that circumstantial evidence is not necessarily weaker than direct evidence. What I always feel is that circumstantial evidence cannot lie. It is not a witness that forgets. It is not a family member who gives biased evidence. It is simply that fact was proven, and from that you can, with reasonable certainty, infer that this occurred. So it takes, to some extent, it takes away the human element of direct evidence. Yes, I don't know whether you want me to elaborate any further.
Does circumstantial evidence serve to assist the state in discharging its burden? Would you say, is that what it does?
Definitely, there's I think equal weight should be attached to circumstantial evidence as is done to direct evidence. Yes. And following that, then even if the state's case is only based on circumstantial evidence.
How do you balance it against the state's obligation to prove its case beyond any reasonable doubt in criminal matters?
I think that is where the second leg of the Blom test comes in. It must be the only reasonable inference that the court can draw from the proven facts.
Right. Compelling and substantive evidence is one of those triggers that one's taken into account when we have to depart from a mandatory sentence. What is it that constitutes in the adjudication of facts or circumstances before yourself? What is it that constitutes compelling it and substantial circumstances?
Sorry. Yes, I think the cases that comes to mind in that regard is that of Malgas and Lopez, the Namibian case of Lopez. I always feel that circumstantial and compelling circumstances, it's not something special or extraordinary. It has been decided by our courts many times that all the usual circumstances that the court does take into account, specifically regarding the personal circumstances of an accused, the cumulative effect of those personal circumstances combined can constitute a substantial and compelling circumstance. The court should, however, be careful not to deviate from a minimum sentence for flimsy reasons or because it has sympathy for an accused who has to go to prison for his first offense, or even in some instances where it might be that the presiding officer is not in agreement with the policy created by the legislature through the institution of mandatory sentences.
If it's not something special in terms of what we have to look at, would you say it's an objective standard that is being applied here in taking those circumstances into account? Or does subjectivity plays any role?
I don't know. Objectively speaking, if you have an accused that, I do not want to use but that ticks all the boxes. That is useful. It's a first offender who maybe has 1 or 2 children, who has remorse for what he has done, who has maybe spent 5 years in custody already. Then, objectively speaking, from the court's point of view, the cumulative effect of those circumstances, in my opinion, would be a substantial and compelling circumstance.
Right. By now you would have presided over several Section 174 applications. What are those considerations that you take into account when adjudicating 174 applications?
I actually phoned a colleague of mine and I asked him, I am very confused by the case law at the moment. Does the second leg of the shipping test still stand? And his answer was, it depends who you ask. But yes, the shipping test is still the benchmark, in that is the evidence upon which a reasonable court, as was said in the Teka Nakali cases, acting carefully, will convict the accused. And then also, is there a chance that the accused might supplement the state's case? I am of the opinion that if the state's case is weak, there should be no duty on an accused to come and testify in his defense to supplement, or in the hope that he will supplement the state's case. I do feel that it would be contrary to Article 12 of the Constitution, in that it places a duty on the accused to incriminate himself. So yes, there's also other considerations where, for instance, it's been decided many times that the court should look at the totality of the evidence that has been presented to it. In the Simon and Van Rijn cases, the court went so far as to say that the plea explanation that the accused has given in terms of Section 115, where he maybe discloses, or what mostly happens is that he discloses a defense of private defense, many times in quite detail, then that in fact places a duty of rebuttal on the state to negative such a defense, and that the court, when considering a Section 174 application, is in fact allowed to view the plea explanation as part of the evidentiary material before it. If, for instance, as happened in the Van Rijn case, the state witnesses themselves in effect corroborate the plea explanation of the accused, then the court in such instances is in fact allowed to grant a Section 174 application, even though the state will then not have an opportunity to cross-examine an accused on his defense of private defense.
Does the test relate to what the court might convict on or could have convicted on?
Could?
Could.
Might. Very well. Now, I would like to invite Commissioner Kamba to pose their questions, please.
Absolute, that can under no circumstances whatsoever be limited or suspended.
The right,
even in a state of emergency?
the right to life, I would assume.
Anything else?
I can think of instances where the other rights might possibly be limited. So yes.
What is your understanding between the fundamental or the main differences between appeal and review proceedings?
The court, who sits as a court of appeal, the High Court, as it relates to the lower court cases, has the same powers as are granted in Section 304 of review. However, so those are the same. However, a court of appeal does have greater powers than this microphone is making funny noises. Thank you. For instance, I think that was also a question in the test. There is case law saying, and I agree with that, that a court on review cannot increase a sentence. It is not mandated by the wording of Section 304. However, a court sitting as a court on appeal, court of appeal, under the circumstances mandated where the sentence induces a sense of shock or is startlingly inappropriate, then a court of appeal would be able to increase the sentence. So the purview of an appeal court, in my opinion, is then greater than that of a review court, but it includes everything that a review court can do. Yes, the court is only allowed allowed is maybe the wrong word, supposed to look at the specific grounds of appeal. In other words, if the ground or the appeal is only against the sentence, that forms the only ground of appeal. But when going, then the court is only supposed to look at that. However, Section 16 of the High Court Act does give review powers to the High Court, which includes, for instance, I think there are 4 grounds where there's malice or bias on the part of the magistrate, or where inadmissible evidence was allowed, and also where a gross irregularity took place. And I would feel that if you realize through looking at the record that the conviction is in fact not in order, that would constitute a gross irregularity that can be cured through the use of those powers. I think it can be conducted outside of court, and I think the test should just remain the same, whether the irregularity is of such a nature that it renders the trial so unfair, so as to say that no trial in effect took place.
Just one last question. You spoke about the inherent or the original jurisdiction of the Supreme Court and the High Court. Does the High Court have inherent jurisdiction to consider the conviction in the case where only sentence is appealed?
Where only sentence is appealed? Yes, yes it does.
Yeah. Thank you, Ms. Duplessis. Now, you're on social media.
Yes.
Yeah, don't specify, please. Don't advertise anything, anybody, anything here. So, but what is your? Do you some have people who befriend you in social media, who follow you?
I only befriend people that I know. I'm on social media to know when the next farmer's market is.
No.
Things like that. So
Yes, I see. I
Old
see.
school.
Yes. So, but what is your take generally about judicial officers' active participation on social
Yes.
media?
Like I say, I use it for informative purposes. I
Right.
think one should be incredibly careful to post or share.
What if you were to discover that somebody posted negative comments about your person, about the way you have handled the case? How would you approach that posting?
I think what our mothers taught us, silence is golden. You do not respond at all. That's, according to me, would be the safest way. You, of course, never have control over what other people say, and I think that is the inherent danger of social media. But, of course, if it crosses a border of becoming contemptuous, then steps should be taken.
Steps. But you take it also that there must be also other institutions that should come to the defense of the judicial officers. Yeah.
I do not think that the judiciary should be defended in the muddy waters of social media. I think the rules are in place. I think there's a great vacuum regarding cyberbullying,
Yes.
sexual harassment. I think our legislature has a long way, and it must do it fast
Right.
to fill those gaps regarding our
Right.
social media and our children.
Right. Is there anything else that you'd like the Commission to know? Something that we have not asked you, but you think it's important that we should know about?
I can just say that I thank you for the opportunity, and I hope my passion for the law shows.
Are
Because
there any
it's
complaints lodged against you at the Magistrates Commission against maybe
nothing.
an accused who is aggrieved by the decision
more
that
than
you
usual,
took,
no.
a member of the public? No. To date, nothing of that sort
Nothing.
has occurred.
Yes.
Right. You are based in Oshuarongo, you said.
Yes.
Well, of course, should you be appointed, I would like to inform you on behalf of the Commission that the Commission is not in a position to provide housing
Yes.
to you, should you relocate to Windhoek. However, as you know, there is a provision in the conditions of service of judges that you're provided with an allowance which would enable you to purchase a property of your own,
Okay.
which you can then use as your residence. So that's a provision that we must all take advantage of and
Yes.
actually do precisely that.
Yes, I
But
understand.
if you were to knock at the Commission's door and said, you recommended for my appointment and now you must provide me with a certain house in
Yeah.
a certain location,
Yeah, it's
well,
just
I'm
my
afraid
husband
the
and I,
bad
so-
news is that that's not possible from our side.
Yeah.
Right.
Okay.
I just wanted to be clear about that.
Okay. Thank
Yeah.
you.
But otherwise, I would like to thank you on behalf of my colleagues, the commissioners, for coming
Thank
to
you.
interact with us. And so I wish you good luck
Thank
with the
you.
outcome of this process.
Thank you so much, and you must all have a good day. Thank you for the opportunity.
You're welcome. Thank you. I see. Next on the line is Mr. Tembwe, Mr. Stanley Tembwe. Mr. Tembe, welcome. You have been nominated for possible appointment as a judge of the High Court, specifically in the criminal stream. But do you feel bound by that nomination that you must always serve in the criminal stream? Or are you flexible? Are you amenable to being appointed in the civil stream as well?
Good morning, Chief Justice. I'm amenable to serve also in the civil stream.
Do you have some experience in a civil court, serving in a civil court?
I only have experience in the civil stream of the lower court, but not necessarily of the High Court.
Yes, very well. But before we go any further, the Commissioner would like to know who Mr. Tembe is. Could you please introduce yourself to the Commissioners and to the nation at large, Mr. Tembe?
Thank you, Chief Justice. My full name is Stanley Mwilima Tembe. I was born at a village called Skanjavuka in Zambezi region, the former Kaprivi region. And I hold a B.Juris degree from the University of Namibia. And I also hold a Bachelor of Laws degree from Cavendish University in Zambia. And my judicial career started in 2007, where I was appointed as a magistrate in Ucho. And then thereafter, in 2009, I was promoted to senior magistrate, moved to Chivarongo. Then thereafter, I became principal magistrate in Grootfontein, and then eventually, now I am a divisional magistrate based in Cape Mansour, where I'm the administrative head for Cape Mansour Division. Right. And being a divisional magistrate, I'm also actively presiding in the regional court. And briefly, in the lower court, I have a combined experience of 17 years and 8 months.
Very well. I'm pleased to hear, Mr. Tembe, that you preside over criminal cases in your division, because that's important. I think that's actually the latest development. Previously, divisional magistrates used to do mostly administrative work. Am I correct in that regard?
You are correct, Chief Justice. I had to step in the regional court because the volume of work cannot be done by one magistrate who is appointed for the regional court. The entire division only has one regional court magistrate, and the stations were just a lot for the regional court magistrate to handle alone.
Right. How many cases have you accumulated so far? First of all, the total number of the cases that you are presiding over in the regional court. If you can break that number into the partly heard cases. And then amongst partly heard cases also, how many are waiting for judgment?
The partly heard cases, Chief Justice, that I have currently, that are active on the court rolls, excluding those where accused are on warrant of arrest, there are 6.
Only 6.
And out of the 6, I do not have any judgment that is pending.
So if you were to be appointed soon, anytime soon, so you are flexible, you'll be in a position to transition to the new posting.
I'm flexible, Chief Justice.
Mm-hmm. You don't have any other maybe administrative work that is pending or outstanding that may affect that transition?
Not that I'm aware of. What usually happens in situations like that, if someone maybe gets appointed, the office usually ensures that there is someone who acts in your position if you are given an acting stint or if you are permanent. There's always some transition that the office takes care of. But like I said, my party heads are 6, and most of them they are at an advanced stage. And they have not been delayed by myself. It has been some chain of other factors that has contributed to the delays. But I'm in control over those matters.
How many regional court magistrates are there in your division?
There's one regional court magistrate.
And what is the volume of work like?
The volume of work, it's not so huge. The whole division has less than 210 cases, but it's just sporadically spread in Cape Mansop, in Mariental, and in Karasberg,
Right.
and also at the coastal towns of Fluderit.
Very well. Now we'll invite the other commissioners to ask questions, if any. But before I do that, because I'll give the Attorney General a chance to ask you a follow-up question, I suppose.
Just to understand, since you are primarily responsible for administration, how many percent of the time would you say is spent doing administrative work, surveillance? How many percent of the time is spent doing court work?
Thank you, Commissioner. The regional court, I'm attending to it for a period of 1 week in a month, because I'm now presiding in the regional court in Luderitz and in Oranjemund. So the sitting of those courts, it's only 1 week in a month. And then the 3 weeks, then I'm on the administration. So there is a court program that is designed to that effect. So there is 1 week in the regional court and then 3 weeks on the administration.
The Deputy Chief Justice, please.
Thank you, CJ. Mr. Temboya, as a High Court judge, in what sort of circumstances is a judge of the High Court, may a judge of the High Court depart from or is not bound by a judgment, a previous judgment of another judge of the High Court?
Thank you. Thank you. A judge of the High Court is not bound by a decision of another judge if the previous decision was erroneously arrived at. And there are numerous judgments where the High Court has distanced itself from the previous judgments that has been delivered in the same court. For instance, there's this matter involving it's a drug-related matter involving Proclamation 277 of 1977, where metacolon was previously categorized under Part 2 of the regulation. And the previous judgments placed metacolon under Part 2 of the proclamation, whereby metacolon was considered to be a potentially dangerous dependence-producing drug. And there was a judgment of the High Court whereby they distanced themselves from the previous interpretation that existed. And the correct view was now that metacolon falls under Part 1 and it's categorized as a dependence-producing drug and not necessarily potentially dangerous dependence-producing drug. So it was remarked in that judgment clearly that the High Court was not, in fact, they indicated clearly that the previous judgments were wrong, and the judgment that they held in that matter was the correct one, which was to be followed.
On the first day, probably that you are going to become a judge, you are going to face recusal obligations. They are very popular these days in our courts. What is the test that you apply to adjudicate the recusal application?
The test for recusal, firstly, there's a presumption that a judicial officer is impartial when adjudicating on a matter and is only subject to the Constitution and the law. There is also some consideration that has to be made. There is some principles that were extensively discussed in the matter of. I'll start with the matter of Bennett versus Absa-Benki, it's a South African judgment, where they discussed the test of recusal. In that judgment, it is said that recusal, a judicial officer can recuse himself or herself on a matter if there are some utterances that he has made during the proceedings, whereby if those utterances are made, they create a reasonable apprehension of bias in the mind of a litigant. So, in the Louis January matter, Louis January versus the Master of the High Court, there is also what is called the double reasonableness test. The double reasonableness test entails that, firstly, there has to be a reasonable apprehension of bias in the mind of a litigant before a judicial officer decides to recuse himself. And then the second leg is that the basis upon which the recusal is premised must also be reasonable. And then that was the principle that was mentioned in the matter of Louis January versus the Master of the High Court. In that matter, they also confirmed the recusal principles that were discussed in a constitutional case emanating from South Africa, the Sarfu and others versus the President of the Republic of South Africa and others. So I think in that judgment from South Africa, they extensively also discussed the double reasonableness test on recusal applications. So generally, a judge is not to recuse himself from a matter just lightly. There has to be cogent reasons and before one decides to recuse himself or herself from a matter. On recusal also, there was also a matter that emanated from our jurisdiction here. It went up to the Supreme Court, where a group of magistrates who were acting in the regional court were eventually not appointed in those positions, and then they decided to abandon work in the regional court on the premise that they were not eligible for permanent appointment. In the High Court, the High Court ruled that the magistrates correctly recused themselves, but when the matter went to the Supreme Court, the decision of the High Court was reversed. The basis was that there was no cogent reasons for those magistrates to recuse themselves from the said matters.
Commissioner Shikongo. Oh, sorry, AG first. I beg your pardon. Thank you. Thank you. Correct. AG first. Well, because you asked the first one, I thought you had.
Mr. Tembe, I want to bring you to the Constitution, our own Constitution, Article 10.1, that provides that all persons shall be equal before the law. However, Article 31, in terms of Article 31, the state president enjoys immunity from civil and criminal proceedings. Now, under which circumstances can the state president be sued, civil proceedings, and under which circumstances can the state president be charged with criminal offenses?
Thank you, Commissioner. A president can only be sued if he is no longer sitting as a president in terms of our constitution.
Sued. You want to
To be
charge him
sued.
for murder. The AG has in mind murder, for example. You are talking about sued.
Or suing, to be sued in a civil proceeding.
No. The other.
What
AG
about-
mentioned criminal.
About criminal. What about criminal? What's the position there?
Under what circumstances can a president be?
Yeah, let's put it this way. Let's start with the civil proceedings. Under which circumstances can he be sued? He or she be sued? The civil proceedings.
In civil proceedings, if in circumstances where the president is alleged to have breached some parts of the law
Yeah.
That official capacity.
Uh-huh.
in the official capacity, but not in the personal capacity.
Presidents are always accused of breaking laws.
But usually,
Occupational hazard.
they are sued in their official capacity.
So in official capacity.
Yes, Commissioner.
There are some proceedings, his personal capacity can he be sued as an office.
Not while he's still sitting as a president.
In terms of the criminal proceedings, what is the situation?
I think the immunity also applies in criminal proceedings. If he's still sitting as a president, he cannot be charged.
Good. Now, during COVID, I'm sure you are aware that the country was placed under state of emergency. That was done in terms of Article 26 of the Constitution that also empowers the president to make regulations that he or she deem necessary for the protection of national security, maintenance of law and order, and public safety. Under those circumstances, can the president suspend common law, statute law, any rights or freedoms that are protected in terms of the Constitution? So under which conditions?
Just repeat once more, Commissioner.
Yes. Just think about COVID time.
Yes.
Country was under state of emergency. And under 26 of the Constitution, the president is empowered to make regulations that he deemed necessary for the protection of national security, for maintenance of law and order, public safety. Now, since the president is given so much power during the state of emergency, is he also entitled to suspend certain laws, statute of common law, or to suspend the rights and freedoms that are provided
answer is yes, he is allowed to do so. If I recall well, during the COVID period, the right to movement, free movement of people was also curtailed. It was done so because it was in the best interest of the people of the country that movements were curtailed in order to contain the situation that was there at the time. But I can also mention that curtailing those rights that are enshrined in the Constitution has to be justified. The President cannot just, or should not just, curtail those rights as it pleases him, because those rights are not supposed to be derogated from, lightly.
Are there any limitations you understand to the exercise of such power, whether in terms of conditions imposed or in terms of the time period within which the state of emergency will remain in place?
Are there?
Are there any limitations?
Time limits.
Time limits.
Or time limits?
Yes, Commissioner. Not, I think there are time limits set because, for instance, the state of emergency regulations should not be implemented for a lengthy period of time. For instance, if the reason that triggered the emergency has fallen away, it wouldn't be justified for the state of emergency to continue.
In reply to one of the preceding questions, Mr. Tembe, you indicated that you spend 1 week a month on adjudication, whereas the rest of the month is dedicated to administration. Is that the case, and for how long a period has that been the case? And is it from 2007 since the appointment as divisional magistrate?
This only emanated from 2022 when I became a divisional. But before that, when I was still in the district, the time for sitting in court was full-time every day.
So it is now full-time and no longer 2 weeks or 1 week per month?
No, I'm saying before 2022, I was still in the district court. So the whole time from 2007 to 2022, I was full-time in the court. When I became divisional, that is where I now had to be taking care of the regional court and also be a divisional at the same time.
And how long has that been the case, where your duties seems more assigned or skewed in favor of administration?
From 2022.
2022.
Yes.
Okay. You've had an opportunity to adjudicate on circumstantial evidence when the state is challenged as far as the availability of direct evidence is concerned. How do you go about evaluating circumstantial evidence?
On circumstantial evidence, that is an aspect that one encounters when adjudicating in criminal matters. So the approach on circumstantial evidence is that if it's the only piece of evidence that the state are relying on, as a judicial officer, you can only convict if the evidence at hand draws the only conclusion. I mean, if you can draw conclusions from that, from the circumstances, and your conclusions or let me put it like this. when faced with circumstances of circumstantial evidence, the court has to consider other surrounding circumstances. And if the only conclusion that the court can draw is that the accused indeed committed the offense, only then can a court convict an accused, where reliance was only based on circumstantial evidence.
Are you familiar with the locus classicis in the instance of circumstantial evidence, your main case in this area?
The leading case,
The leading
on
case.
circumstantial evidence.
Leading case on
You
circumstantial.
must be applying it almost on a routine basis.
I've read some judgments on circumstantial evidence.
If you don't know, you don't know. You can just tell us.
I cannot cite one with certainty. But the principle, I'm very much aware of the principle.
Right.
I've applied it several times.
Often you adjudicate on a crime where you have a mandatory sentence applicable and prescribed. Sometimes there's a key to deviate from that by way of exception. What is it that you will take into account in the deviating from a mandatory sentence as a presiding officer?
For instance, in rape matters, there are some minimum sentences. So the court can deviate from the minimum sentence if the cumulative effect of the sentence will be unjust to the accused. For instance, if an accused is charged with maybe 4 counts of rape and the minimum sentences is maybe 15 years on each, and then the cumulative effect draws the sentence maybe to 60 years or so.
Are you familiar with the concept of substantial and compelling circumstances?
Yes, Commissioner, I'm aware.
I think the commissioner wants you to discuss that.
Substantial and compelling circumstances, usually the court is not allowed to easily deviate from the prescribed minimum sentences. This was discussed also in the matter of S versus Lopez. So the deviation from the prescribed minimum sentences is not something that just comes automatically, but it has to be justified. There has to be something peculiar in the accused mitigations that will entitle, a court to deviate from the prescribed minimum sentence. One of the instances I mentioned was situations whereby the cumulative effect of the sentence, if they are to be given their full effect, will be unjust to the accused. And then the other...
Even if it's mandatory?
Pardon?
Even if it's mandatory?
Yes, even if it's mandatory, a court may still deviate if there is presence of substantial and compelling circumstances present in the circumstances of the accused.
Yes. Commissioner Kamba, please, would you like to come in? Thank you.
If you sit as a judge of appeal in an appeal against sentence only, and an accused person informs you on the day of the hearing that he also wishes to appeal against his conviction, how would you handle that situation?
Just repeat once more, Commissioner.
As a judge of appeal, you'll recall that in the High Court, you will also be sitting on appeals, reviews, and so forth. You're not necessarily a court of first instance. So when you sit as a judge of appeal in the High Court in an appeal against sentence, but on the day of the hearing, an unrepresented accused informs you that he also wishes to appeal against his conviction,
You mean,
how would you handle the situation?
you mean his conviction in the High Court?
No, his conviction in the magistrate's court. You're sitting as a judge of appeal.
You remember when should you be appointed in the High Court, you also have to sit in the judgment of your former colleagues at the magistrate's court level, isn't it? Now, the question that you are being asked now relates to you performing your duties as a court of appeal in the High Court. Commissioner, would you like to go through the question again so that...
Of course, Chief Justice. So what is before you? You're sitting now as a judge of appeal in the High Court. So what is before you is an appeal against sentence. But on the day of the hearing, an unrepresented accused informs you that he now also wants to appeal his conviction.
Thank you, Commissioner. On that subject, if an appeal that is before me is based on, I mean, if the accused is appealing against the conviction, I am only bound to hear the appeal based on the ground that was arisen in the notice of appeal. I cannot automatically hear the appeal based on the recent averment that has been brought now by the accused person, because I have to adjudicate on that appeal based on the appeal that was filed. The issue of conviction cannot automatically be brought at a stage where the hearing is about to be held.
Okay, and when you consider now the appeal against sentence, when you read the record that accompanies the appeal from the lower court, if it appears to you that the conviction was incorrectly made in the lower court, do you have any power to address that situation?
Yeah, inherently, I have powers to address it.
And how would you go about it?
I will address it from the angle of me having become aware of that aspect while adjudicating the appeal based on the conviction, but not necessarily at the prompting of the accused person.
But remember, in the factual scenario that I gave you is that you're sitting on as a judge of appeal against sentence only. So before you is an appeal against sentence only. The accused person never noted an appeal whatsoever regarding his conviction. He appealed his sentence only. But when you read the record, it becomes clear to you as the judicial officer or the presiding officer that the conviction was also incorrectly made. Do you have any power to address that issue?
I have the power to address the issue.
And how would you go about it?
How do you go about it? And on what principle? If you can recall.
I cannot recall the specific principle, but I
Right.
know that the Constitution allows me to address such issues,
Right.
and also the High Court.
Very well. You're also familiar with Section 61 of the Criminal Procedure Act, circumstances where bail is applied for in serious, where persons are incarcerated for serious offences contained in Schedule 2. You're familiar with the section. That section requires a judicial officer to do an inquiry as it deems necessary. Can you explain to us what that entails? How is that bail inquiry conducted?
Maybe I'm not getting it clearly.
Section 61 of the Criminal Procedure Act says or provides that where an accused who is in custody in respect of an offence referred to in Schedule 2, where he applies for bail, then or to be released on bail, then the court must, or the court can refuse the application for bail if, in the opinion of the court, after such inquiry as it deems necessary, and if it is in the interest of the public and the administration of justice, the court can then refuse bail, or only grant bail if it is of the view that it is in fact in the interest of justice and so forth. How, my question relates to the inquiry itself. It requires the presiding officer to conduct an inquiry. How should a presiding officer go about that inquiry?
Thank you, Commissioner. The inquiry will be in a form of, usually where Section 61 is invoked, it comes when there is a bail application, where both the state and the accused are afforded an opportunity to, for instance, an accused is afforded an opportunity to address court or to lead evidence as to why he should be released on bail. And the state also is equally afforded an opportunity to present evidence as to why the accused should not be released on bail. And in that inquiry, there is a duty on there is a duty that is on. I mean, there is a duty on the side of the court to establish from the parties that, to establish whether number one, the accused is not a flight risk, and there is also reasons to establish that it will not be in the interests of the administration of justice for the accused to be released on bail. So it's not something that just happens automatic. The state and the accused has to be given an opportunity to make, presentations to the court.
Yes, and after both parties, both the state and the representation for the accused have made a representation and called their witnesses, does the presiding or would the presiding officer under those circumstances have the power to make further inquiries?
Yes.
Of its own motion? Can the court of its own motion make further inquiries?
Yes, the court can do that.
One of the requirements of that section is it provides specifically if it is in the interest of the public or the administration of justice. What do you understand under those two phrases? The interest of the public or the administration of justice?
If I heard you correctly, you are inviting me to describe what interest of justice means.
Yes. The Criminal Procedure Act, as you likely know, do not define those two or those phrases. There is no definition in the Section 1 of the Criminal Procedure Act. So what do those phrases mean then?
You see, on that subject, there is no exhaustive list. The court has to make a finding as to what necessarily amounts to the interests of the administration of justice. And circumstances usually differ. So it is a duty of a court to make a finding on what necessarily amounts to the administration of justice based on the circumstances that are before court.
Very well.
Yeah. Yes. Thank you, Mr. Temwe. Is there anything else that you would like to let the Commission know from your side? Not something that, that we've asked you?
No, Chief Justice.
No complaint has been lodged against you? at the Magistrates Commission, to the best of your knowledge?
I have no complaint.
No complaint, no complaint. Any financial interests that you may wish to disclose to the Commission?
No, Chief Justice, I do not have.
Nothing of a personal nature that you may wish to bring to the attention of the Commission? Of course, being personal, once it comes out in the public domain, it's no longer personal. If I may just put a caveat.
No, that I'm aware of.
Okay. Thank you, thank you. I wish to thank you for coming, but I wish to inform you that should you be appointed, you should make use of the facilities placed at your disposal to acquire property of your own. The Commission is not really in a position to provide housing. You might have read somewhere, somehow, where it says something that provision of housing has been mentioned, but I want to tell you now that we are not in a position to make that facility available. So you must make use of the other facilities that are placed at your disposal.
Noted, Chief Justice.
I'm saying that because I know you may be coming out from outside this region of commerce. If you don't have property of your own, maybe you might have to find accommodation. I'm saying that on the assumption that you are appointed. And it's really not a promise. Okay, very well. Thank you, and good luck.
Thanks.
Last but not the least, Mr. Mwilima, Elvis Mwilima. Yes, very good. Please take your seat, Mr. Mwilima. Thank you. And welcome to the Commission.
Thank you very
You know all the commissioners here. In the event that you may not know all of them, they have been identified. But we would like to know more about you. Could you please introduce yourself to us? Who is Elvis M. Mwilima, and what does the M stand for?
Thank you very much, Chief Justice. My name is Elvis Mwilima. I'm currently the Divisional Magistrate of the Oshagati Division. I joined the legal fraternity in 2010, having graduated from the University of Namibia. I joined the legal fraternity through the PG's office as the public prosecutor, Tondangwa Magistrates Court. There I prosecuted from 2010, July 11, up until 2013, March. In 2013, March, I joined the bench, the magistrates. I've been a magistrate since 2013 to date. I worked in Ocho as a junior magistrate. I was then moved to Otavi, still as a junior magistrate. And thereafter, I was transferred to Grootfontein. I also worked there as a junior magistrate in 2016. In the same year, I was then promoted to senior magistrate in Marienthal, where I spent close to 5 months. And thereafter, I was again promoted to principal magistrate, where I was relocated to Oshinene. In Oshinene, I also stayed for a few months, if not 5 months, roughly more or less. I was then transferred to the Window Relief Department, where I spent close to 4 years, until 2021, May, when I was eventually appointed as a divisional magistrate of the Oshagati Division.
Right.
And that is where I find myself, and that is who I am now, Chief Justice.
So you were appointed divisional magistrate which year again?
2021.
2021.
May.
Right.
That's in short who I am.
Very well. As a divisional magistrate, do you preside over cases in court?
Yes, Chief Justice. I preside over cases in the district court and also in the regional court.
How many cases or partly heard cases do you have in the regional court to start with?
In the regional court, currently I have I'm not mistaken, I think I have 3.
3.
Yes.
At which stage are they, if you recall?
One is a defense case in Chumeb. The other one is still a state's case. The accused decided to apply for legal aid in the middle of proceedings. And
Where, in which district is this?
in Oshakati, at the Regional Circuit Court of Oshakati.
Right.
The one with defense case is in Chumeb. And I think that is
Very
it.
well.
The rest I have maybe 2 or 3 in the
And
district.
how many do you have in the district court?
So far, I can say
Partly headed.
partly had not more than 4.
Not more than 4.
Yes.
So in total you have about 7.
Probably 7 years. Some of them I picked them after the application.
Right. Now, should you be appointed, how much time would you require to finalize your cases? And what is the time frame that you have set for yourself to finalize those cases? Not that to take up the new appointment.
Most of those cases are almost at the tail end. For the one for Chumeb, I'm hoping that we finalize it when I go back in June. Then the one for Shakati, I understand a lawyer has been appointed and it is ready to proceed. So roughly 3 to 4 months.
3 to 4 months.
I will be able to dispose of those cases.
Very well. Very well. CJ, would you like to come in with questions?
Thanks, CJ. Mr. Milima, the sentencing jurisdiction as a regional court magistrate is of course different from that as a district magistrate.
Yes, DCJ.
And if I understand you correctly, you have been effectively regional court magistrate since 2021.
Yes, DCJ.
That means about 4 years.
Yes.
And during that period, you dealt with roughly how many cases?
DCJ, because I actually do regional court on ad hoc basis, because I'm an administrative head of the division. So I go into court when the judicial officer substantively recuses themselves on some matters. I can say so far I've dealt with, I think, 3 or 4.
So in effect, you have limited experience as a regional court magistrate compared to exercising your district court jurisdiction.
Yes, one can say so, because I've done few cases in the regional court compared to the cases that I did in the district. I can say that most of my life I've dealt with cases in the district. Regional court, I started dealing with those cases since 2021, but I can say I finalized quite a number of them in the regional court.
Understood you to say 3.
Yes, the one that I can remember.
That's the one you are referring to as quite a number of them.
The one that I can remember, DCJ.
Okay, no, I just wanted to clarify that first.
Yes.
And now, Mr. Milima, can you explain to us the principles that we apply in recusal applications?
Thank you, DCJ. In a recusal application, the test for recusal is that of an apprehension of bias, which is an objective test, a perception from a reasonable apprehension of bias, which is based on a perception from a reasonable person, and should also be based on reasonable grounds. So that is basically the test for recusal. The question is, will the magistrate or the judicial officer be in a position to bring an impartial mind to bear in the adjudication of the trial or the matter that is brought before you? Okay. If that is if you feel that you will not be impartial in the adjudication of the issue of the matter that is brought before you, and one can recuse himself or themselves. But basically the test is based on a reasonable person's test, who is informed and who is relying also on reasonable grounds of apprehension of bias.
Okay. Explain to us what you understand by the doctrine of precedent, stare decisis.
Stare decisis is the doctrine that speaks of judicial hierarchy, that all decisions of superior courts are binding on the lower courts, and the lower courts are bound to follow the decisions of the higher court. That's my understanding of the doctrine of stare decisis.
Honorable EJ.
Thank you, Mr. Mulima. In terms of our constitution, the president enjoys certain immunities from civil and criminal proceedings. Now, under which circumstances can the president be sued in civil proceedings, and under which circumstances can the president be charged with criminal offenses?
Thank you very much, Commissioner. I think the starting point is that the president is immune, like you said, from criminal prosecution of actions that are taken in the course of his work as a president or the head of state. However, not necessarily that the president can be sued, but the government can be sued, and then, if there are certain decisions that are taken that are injurious to maybe to the rights of the citizen or members of the public. That is the one instinct that I can think of.
Are you familiar with any specific article in the Constitution that deals with this scenario that you have just described?
Currently now, CJ, I cannot think of
You
it.
can't remember. Yeah.
But in your own understanding, can the president be sued under any circumstances?
But the immunity principle is that the president cannot be sued in his personal capacity. But for certain administrative decisions, I think an action can be brought, but through the government of the Republic of Namibia, not through the president himself.
Right. In terms of the Constitution, the president also enjoys certain powers even to make laws through regulations. Article 26 of the Constitution powers the president to make regulations of proclamation, and those regulations can only be made if he or she deem it necessary to maintain law and order, to protect national security, public safety. Now, giving such wide-ranging powers that are given to the president, can the president also, would the president be entitled to suspend any laws or to suspend the rights and freedoms that are granted in terms of the Constitution? So, under which circumstances or conditions?
Thank you very much for that question. The Constitution, the supreme law of the land, and all the decisions that are taken ought to be in conformity with the provision and consistent with the provisions of the Constitution. There are instances, however, where the president can, through proclamation, brings into the operation, for example, the issue of the state of emergency. That is a circumstance under which the president can actually bring in a regulation to actually regulate certain movements, but not to take away the rights, especially Chapter 3 fundamental rights. Those cannot be taken away, but they can be limited to a certain, the exercise thereof can be limited to a certain extent on the basis of maybe the looming security concerns. An example that I can think of is what the situation that happened in 1999 during the treason, the secession attack on the government satellite. That is the situation that I can think of. One of the rights, for example, that can be limited through the President's proclamation is the right of movement, for example.
Thank you. Commissioner Shikongo?
William, morning.
Morning.
When faced with an application in terms of section 174, that's now at the end of the state case, what is it that the presiding officer must take into account?
Okay, the test for section 174 is as follows. Section 174 provides that if at the close of the case for the prosecution, the court is of the opinion or is of the view that the state has actually not made out a case to warrant the accused person being placed on his defense, it's under such circumstances that then the court can invoke that section to discharge the accused person and to actually terminate the proceedings. But what are the considerations now? One of the considerations is, one, you look at the evidence that has been adduced so far. Is the state's case based on the evidence so poor such that no court acting carefully will actually convict the accused person if the accused person decides to remain silent? That is the test. The court will also have to look, for instance, on the evidence that is laid and also look at what has been adduced during cross-examination in the course of the trial by the accused or by the defense, in the determination where that there is sufficient evidence to warrant the accused to be placed on his defense or to be discharged. I can think of a number of authorities, for example, prior to 2000, if my memory serves me right, the test has always been that if at the close of state's case there is evidence, there is a possibility that the accused will supplement the state's case if he is placed in his defense, then that application should fail. But subsequent to the judgment, I think, of Leroux, the constitutional test now became that there is no way an accused should be placed on his defense under the hope that he will come and supplement the state's case and convict himself at the end of the day. So those are some of the considerations that one would have to take into account when determining whether or not to either discharge the accused or to place him on his defense. Of course, also having regard to the constitutional presumption of innocence and the fact that the accused has no duty to prove his innocence.
And when as a presiding officer you are confronted by what comes down to circumstantial evidence, that's now in the absence of any direct evidence from the state, how do you go about evaluating that circumstantial evidence to arrive at the verdict?
Circumstantial evidence, the authorities say, circumstantial evidence is actually evaluated through inferential reasoning. You apply the principle, I think, in Plascon-Evans rule, where you...
Plascon is something else. Plascon-Evans is something else, isn't it? It's motion proceedings.
Are you familiar with the leading case in circumstantial evidence?
Yes, I am familiar with one of the cases. State v. Sawala is one of the authorities where Liebenberg actually discussed the issue of inferential reasoning, where there is no direct evidence. The court will be allowed now to draw inference from the proven facts. There is also another authority of state v. Diploma, where you look at the facts that are established, whether or not from the evidence that is laid and the fact that are proven, there is one inference that can be drawn and not multiple inferences. But
amongst those three that you've just mentioned, which one is the leading case?
From the locus classicus case is the Blom judgment. That's the leading authority that I can think of right now.
Okay. There are circumstances under which you might need to deviate or find yourself compelled to deviate from mandatory sentence. In doing so, you'll be, that's what case law prescribes, have to consider compelling and the substantial circumstances. What are those compelling and substantial circumstances you take into account?
Compelling and substantial circumstances are those factors, not necessarily that they should be exceptional circumstances compared to the other normal factors that one ought to take into account. But authorities have always said, especially in cases of rape, that where the court has to deal with the issue of substantial and compelling circumstances, the court must look at court must actually look at one can say maybe almost extraordinary factors, although they may not be special, those that if you take them into account, you will then be in a position to deviate from the mandatory minimum sentence. I can just think of the number of authorities that have dealt with the Section 3 of the Combating of Rape Act, where the Malhas judgment, for example, laid the test for compelling and substantial factors, where they say these factors need not to be, special. One can take the normal personal factors that the court normally takes into account, and then after having done an evaluation, determine whether they are weighty such that they would warrant the court to deviate from the sentence that is prescribed by the legislature. But what is important is that the mandatory sentences should not be deviated from for flimsy reasons, but it should be factors that are weighty.
Thank you.
Thank you, Commissioner Shikongo. Commissioner Campbell?
If you were to be appointed as a judge of the High Court, you will obviously also sit as a judge of appeal against judgments of your former colleagues in the magistracy. So if you sit as a judge of appeal in an appeal against sentence, under what circumstances can the High Court interfere with a sentence given by a magistrate's court or any lower court?
That is on appeal now. The High Court is entitled to interfere with the sentence of the lower court or the magistrate's court if the High Court is of the view that the magistrate did not exercise the sentencing discretion appropriately or correctly. That is one of the instances that the court can interfere. For example, the magistrate did not, or the judicial officer did not apply his mind to one of the factors that ought to have, given weight. The personal circumstances were not balanced with the seriousness of the offense and the interest of society. Or for instance, where one factor was overemphasized, it is at the expense of the other. Because there is a need for a balancing exercise during sentencing. But if the magistrate does not take into account some of the important factors that he or she ought to have taken into account, then the court can then interfere with the sentence. Another aspect I can think of, maybe if the sentence is not competent in law. For example, in case of maybe statutory ordained sentences. If, for example, the mandatory minimum sentence, the law says, if you find that there are no substantial and compelling circumstances that are existing, you should give, for example, a sentence of not less than 15 years. And the magistrate goes and gives a sentence of 10 years. That sentence will not be competent in law, and the High Court is entitled then to interfere with that sentence.
Very well. Under the same circumstances, you're also sitting as a judge of appeal in an appeal against sentence only. On the day of the hearing, an unrepresented accused informs you that he wishes to appeal against conviction also, in addition to only sentence, which is before you. How will you handle that situation?
Because now the matter is already set, the trial ought to proceed. But if the accused person informs the appeal court that he intended actually to appeal against the sentence, against the conviction as well, I should say that it's a bit of a tricky situation for the appeal court. But at the end of the day, the justice dictates that the court should not close its doors to a litigant, especially if the litigant is a layperson. I would have to assess this, maybe let me quickly ask for clarity. This time, the matter is now ready to be argued before the judge.
Yes.
Yes,
Or it is not being argued.
It's on the day of the hearing.
it's
Okay.
before you now as we speak.
Council all dressed up.
That's a bit complicated, but if the matter is already ready for argument, and I will have to ask counsels, but this one is unrepresented. I'll have to ask the representative for the respondent, for example, for the state, to address me on the legality of the approach that a layperson, whether or not the court can allow a layperson who, for maybe one or the other reason, for lack of knowledge and understanding, had applied against the sentence, but now decides he wants to move an appeal against the conviction. But ordinarily, the court will have to proceed dealing with the issue of the appeal on sentence. But then the problem there will, once the appeal is ventilated and is finalized in the High Court, it can no longer come back to the High Court again. So the option that maybe that I will have to take into account there is to either stand the appeal down and grant the accused person an opportunity to amend his notice of appeal with an application for condonation, of course, explaining the reasons
What
as to
is
why.
the source of that power?
The source of that power is, one, the High Court has got inherent jurisdiction. The court can actually rely on one of the inherent jurisdictional powers, or the Constitution of the Republic of Namibia, and yeah, but there are only two. The court can only exercise, in such scenario, the source will be, the court can exercise its power in terms of the inherent jurisdiction, because the Criminal Procedure Act,
Yes,
the one that deals with the appeals, section 316,
yes.
also makes provisions for amendment to the notice of appeal. However, that's why I say this is a tricky situation, that the appeal is already ready for hearing. The only thing that one can do maybe is to have to postpone the hearing and allow the unrepresented litigants to deal with the
Duty as
notice.
a judge is to resolve tricky situations.
That's
Yes.
precisely why. So
Yes, so,
it's not a walk in the park. It's
but the
not.
at the end of the day, the constitutional right of an accused person to litigate his or her issues before the court is the paramount consideration of the court. So it would not be appropriate for the court to close its eyes and actually show the appellant the door, who, on the account of being a layperson, could not bring a substantive appeal on the conviction, even if he wanted to do so. So I will exercise my powers in terms of the inherent jurisdiction and also in terms of the High Court Act.
Very well. Can you just shortly explain what you understand under the term "in the interest of the public or the administration of justice" as contemplated in section 61 of the Criminal Procedure Act? Just to remind you, that's the section dealing with an application for bail where an accused person is charged with a Schedule 2, the more serious offences. What do you understand under those phrases?
Thank you. My understanding of what is in the interest of the administration of justice. One, like you said, that section 61 of the Criminal Amendment Act says the court, when dealing with those cases that are scheduled offences, dealing with the issues of bail, the court may still refuse bail for the accused person, even if the traditional grounds for bail are satisfied. For example, even if the accused person is not a flight risk, he will not interfere with investigation, but then the court finds that the offense is one that is serious in terms of that legislation, that the offense is one that raises public indignation, that warrants that the accused cannot be kept outside custody pending trial, then that provision says that bail should still be refused. However, The consideration thereof is one that has to do with the issue of value judgment, because the court then must take into account a number of other factors in and over and above the normal one that I referred to here, whether or not he is a flight risk or not. But whether releasing him on bail will maybe arouse public outcry, will then endanger, for example, even the safety of the accused himself, because the offense that he committed is one that has raised quite a serious concern to the public. Then the administration of justice in that regard will dictate that such person should not be granted bail, but retained in custody, because the administration of justice will be jeopardized if, for example, such a person is granted bail.
Thank you, Mr. Mwilima. Is there anything else that you would like to let the Commission know from your side? As you have heard from us, maybe you also feel there is something that you consider to be important that we should know as a Commission.
All I can say is that this was quite a short session. I expected it to take a bit longer, but there is nothing from me that I would say I need to bring to the attention of the Commission.
Right.
Nothing really.
You want some more questions? We have more questions if you want to engage us a little longer.
No, I have no problem.
Yeah, thank you. So no complaints have been lodged against you seriously now by by accused persons, as it often happens, or members of the public about the way you handled a case or a matter, to the best of your knowledge?
I'm not aware of any complaint
Yes.
that maybe one of the public members raised against me or that is pending before the Magistrates Commission.
Yes.
I'm not aware of any such. I know that a few days ago, I think yesterday or the day before yesterday,
Yes.
there was a letter that was forwarded to me from the Office of the Chief Magistrate, but that was not really a complaint against me. It had to do with the absence of the judicial officer from the court at the Ohangwena district. And the member of the public was raising a concern that they are not happy that the magistrate was not at court at that time, and we need to respond to that. But so far, that is the only issue that I know.
Do you have any financial interest that you think the Commission should know that may have an impact on your work as a judge should you be appointed?
I do not have any financial interest. The only financial interest I have is only in my salary. I don't have any other.
So you have not disclosed anything, any interest to the Magistrates Commission?
No, I don't have any other outside source of income except.
No, you don't have to declare your salary because we know where it's coming from.
Yes, I don't have any other external source of income from.
Thank you.
External sources.
Thank you, Mr. Mwilima, for coming.
Thank you very much.
Good luck.
All right.
With your. Thank you. We now have come to the end of our proceedings today. The Commission will now adjourn to deliberate on the interviews or interactive session that we have had with the nominees. Thank you for listening to us. Thank you for watching, and also thank you for being here. That has brought us to the end of the proceedings. We'll now adjourn.